आज तो वो आप लोग रेनी डे का सर्कुलर किए हैं, तो आज कोई अर्जेंट केस नहीं हो सकता।
नहीं तो आज के लिए नहीं है, हम नेशनल कलर फाइलिंग नंबर से परसों फाइल किए हैं। इसमें अर्जेंसी है मेरे की द जूनियर प्रोमोटीज, जिसको प्रमोशन मेरे बाद 2 साल 4 साल बाद दिया गया ऑन द पोस्ट ऑफ इंस्पेक्टर, उनको मेरे अबव प्लेस कर दिया गया सीनियरिटी लिस्ट में, और लिस्ट भेज दिया गया है जेपीएससी को प्रमोशन देने के लिए। तो अर्जेंसी बस
इतना कोई अर्जेंसी नहीं है दैट यू कैन नॉट वेट फॉर द
मतलब लिस्ट आ जाएगा तो फिर सारा इनफर्टाइल
नहीं होगा।
प्रमोशन हो जाएगा तो कुछ
अभी
बचेगा।
आपका डिफेक्टिव पिटीशन का वैसे ही
डिफेक्टिव नहीं, मेरे तरफ से सब कुछ क्लियर है, बस स्टैम्प रिपोर्टिंग नहीं हुआ है, इसी के लिए हम
इसीलिए आप यहाँ मेंशन कर रहे हैं।
नहीं, वो बस स्टैम्प
वो
रिपोर्टिंग।
अपने स्टैम्प रिपोर्टिंग करके उसको डिफेक्टिव करेंगे तभी हो सकता
From the supplementary list, fundraising for hearing item 1 essay 80 of 20.
पानी आज बहुत पड़ रहा है।
क्या चीज़?
पानी बहुत पड़ रहा है।
बारिश का मौसम में पानी नहीं पड़ेगा तो क्या ही पड़ेगा।
नहीं, ट्रैफिक हम लोग के हाई कोर्ट के गेट नंबर 1 पर बहुत जाम है, बिकॉज वो इंटरसेक्शन है जेएससी की तरफ से जो रोड आती है।
जाम तो डोरिंडा में भी लगता था सर, जाम के हिसाब से
जाम
आदमी
तो
को
लगता
एडिशनल टाइम लेके आना पड़ता है, एडिशनल टाइम लेके घर छोड़ना पड़ता है। दैट इज द वे इट इज। हमारे चलते कोई पूरा रास्ता खाली हो जाएगा ऐसा थोड़ी हो सकता
हाँ,
है।
वो भी करता है। हम ही लोग खाली करते हैं।
कम्यूटिंग टाइम आदमी को, जैसे ट्रेन के लिए कम्यूटिंग टाइम रखते हैं ना, ट्रेन में अगर 10 बजे ट्रेन है तो
हाँ, तो कम से कम 9 बजे
45 मिनट्स पहले
हाँ।
निकलते हैं ना घर से, वैसा ही कोर्ट का टाइम ट्रेन के टाइम की तरह होता है।
हाँ,
आप बताइए क्या बोलना है? कल तो हम लोग ऐसे प्रिलिमिनरी सुने थे,
माइंड
आप अपना फाउंडेशन फैक्ट देते हुए
वही हम चाह रहे थे। रात को हम सोचे कि करक्स और की केस पहले
आप अपने हिसाब से पैसे देते हैं।
My lord, this second appeal was admitted on 2 substantial questions of law on 18th of January 2012. The questions of law were whether, in view of the agreement for sale, Exhibit A, the suit property was a vacant land, and therefore suit for eviction under the Bihar Building Lease Rent and Eviction Control Act 1982 was not continued. And number 2, B, whether the land court below failed to consider and urge to hold that the relationship of landlord and tenant did not exist by and between the plaintiff vendor, Narendra Prasad Sinha, Ilyas Buddulal Sinha, and defendant appellant under the Act. Since the sole respond, now the other are the formal. Subsequently, the lordship said the appellant will be at liberty to formulate other and further substantial question of law at the time of hearing of the appeal. So this was admitted on 18/1/2012, my lord. The case of the plaintiff, my lord, in short is that he entered into an agreement for sale on 14/8/2086 1986. It is 1986. With the owner of the property, Sri Narendra Prasad Sinha. His alias name was Budhu Prasad Sinha. However, the suit was filed by the plaintiff, Chintu Devi, saying that she has purchased the property on 21/8/1997, 11 years after. From the same Narendra Prasad Sinha alias Budhu Prasad Sinha.
By registered deed.
By a registered deed, date is
21/7/97.
जी
21/8/97.
21/7
21/7.
March. Yeah. 21/8 है. I may be corrected to be correct. आज तारीख 21/8/1997. According to the plaint, in October 1997, a notice for the rent was given to the defendant. The defendant
By
replied
By whom?
by the purchaser. On behalf of purchaser, Chintu Devi,
The defendant. By the plaintiff.
by the plaintiff. It was replied by the defendant that there is no relationship of landlord and tenant, and there was a agreement for sale.
What is the date of reply?
In October. Defendant on 18/10/1997. I am reading from the plaint pilot, paragraph 4, at page 3. The defendant on 18/10/1997 sent the reply of the said notice through his lawyer Sri Abhinay Kumar Sinha, advocate Giridi. In the said reply, the defendant falsely, this is the statement in the plaint. In the reply, the defendant falsely denied the relationship of landlord and tenant between the said Narendra Prasad Sinha and the plaintiff. It should have been defendant, but wrongly it is written plaintiff.
Then
And himself. It was also falsely alleged that he took vacant land and himself made construction in the is running the shop. It was also falsely alleged that Narendra Prasad Sinha realized ₹5,000 as premium and was realizing rent at the rate of ₹100 per month. It was also falsely alleged that the said Narendra Prasad Sinha had entered into oral agreement for sale of the premises sitting below, measuring 15 into 8 feet for ₹15,000, and the said Narendra Prasad Sinha agreed to adjust the alleged premium of ₹5,000 against the consideration money of ₹15,000. Apart from that, he made out other false and such allegations in reply to the notice. However, To sum up the crux of the case, my lord,
Yes, please continue.
the learned trial court as well as the learned lower appellate court have referred to Exhibit A of the
The facts end here.
I mean,
Complete the facts and then you can just complete your facts.
from the trial court judgment, my lord, the facts stated, my lord, in the beginning of the judgment at para 3, the further case of the plaintiff is that Narendra Prasad Sinha sold a portion of the said holding, including the premises, to the plaintiff. The premises to the plaintiff by virtue of registered sale deed dated 21/8/1997.
इसके डिपोजिशन वाले एग्जिबिट्स निकालिए. ठीक है. So thereafter the suit was filed.
After the reply of the defendant through the lawyer in August 1997, the suit was filed in March 1998.
Yes. ठीक.
Suit was filed.
What is the period of default?
According to the plaintiff, my lord, the defendant had paid rent to Narendra Prasad Sinha at the rate of rupees 100 till the registered sale deed was executed in August 1997.
And according to you?
According to me, according to the plaintiff, the case is that in 1985 I was elected as a tenant, and
This was according to your written statement also.
yes,
So it is an admitted fact.
the other side also says, the plaintiff also says,
That's right.
and in 1986,
No, I just want to know. According to both the parties, tenancy commenced in 1985.
you know, in my humble submission, before entering into the agreement for sale in July 1986, I was holding a tea shop somewhere else. That has come in the evidence of Gahlor, DW2. And after the agreement for sale on 14th of July 1986,
Yes, you continue, I am hearing.
my lord,
You continue, I am hearing.
my lord, on 14/8/1986, agreement for sale was entered into by Narendra Prasad Sinha and the defendant.
आपका रिटन स्टेटमेंट है
जी, paragraph 8.
पैरा 8 में
हाँ,
you say that you were paying rent but rent was for the land, isn't it?
yes.
This is what you say in para 8, that you were paying rent at the rate of ₹100, but the rent was for the land,
Land.
occupation of the land.
Occupation of the land.
That's
That is,
so rent ₹100 was admitted.
it was admitted.
So इस पे denial का कोई scope नहीं.
है ही नहीं. And in the Iqrarnama also, Exhibit A, dated 14/8/1986, also there is averment कि जब तक जमीन का केवाला नहीं हो जाता है, मुझे 100 रुपए प्रति माह जमीन के उपभोग के लिए दिया करें. Exhibit A speaks so. So, my lord, my challenge to the suit was that it was a vacant land. I had taken it on agreement for sale from the owner, Narendra Prasad Sinha, and since then I was paying 100 rupees till the sale deed was executed in 1997, and my lord, in my humble submission, till the judgment of the learned Lord Appellate Court, I have paid that 100 rupees in the court, and that is kept in the court's custody, my lord. It has not been given to the plaintiff. It is that whoever will be.
From where do you say?
Madam,
From where do you say this?
this is my instruction.
आपके इंस्ट्रक्शन से नहीं चलेगा सर, सेकंड अपील में है, रिकॉर्ड से चलेगा.
It will not have any bearing on
It
the
will have a
plaintiff.
bearing because you have been held to be a defaulter for a rent at the rate of ₹100 per month. Yeah, you
300
have been
rupees.
held to be a defaulter for the
300 rupees.
No, 100 rupees. ट्रायल कोर्ट बोला है 100 रुपीज रेंट आपको देना है.
Just a minute. At least what is used,
एटलीस्ट की ही बात करेंगे ना जब टेनेंसी की बात आएगी तो.
one minute. My lord, I will read para 3 of the trial court judgment.
सर एक चीज आपको बता रहे हैं,
हाँ.
बी वेरी वेरी क्लियर ऑन दिस. क्लाइंट के इंस्ट्रक्शन से प्लीज, और हम आपके क्लाइंट के इंस्ट्रक्शन को रिकॉर्ड नहीं कर सकते.
हम नहीं बोलेंगे, छोड़
तो बस उसको छोड़ दीजिए कि आप 100 रुपए दे रहे थे और जमा कर रहे थे, ये सब कहानी नहीं.
तो छोड़ दीजिए.
ठीक.
My lord, I am reading from the judgment of the trial court.
सर
para
हमारे
3.
उस क्वेश्चन का रेलेवेंस इसलिए खत्म हो जाता है क्योंकि आपके इंस्ट्रक्शंस को हम रजिस्टर नहीं करेंगे. मैटर इज
I am not. I have resigned. I have withdrawn that.
बस उसके
Para
ज्यादा
3
बोलने
of
की
the
जरूरत.
para 3 of the trial court judgment kindly I will place from page 23 of the memo of appeal. Page 23.
ट्वेंटी थ्री में तो सिर्फ केस ऑफ रेस्पेक्टिव पार्टीज हैं. एज आई सी दिस इज द फर्स्ट केस ऑफ
Page 23. Judgment होना चाहिए appellate trial court का.
हाँ, जस्ट इट स्टार्ट्स फ्रॉम
हाँ. In brief, the plaintiff. Para 2 I am reading. In brief, the plaintiff cases that one Narendra Prasad Sinha, alias Ancestral, was absolute owner of the suit property premises, and he was in possession of the same also. the said Narendra Prasad Sinha had inducted defendant as a tenant in the year 1985 on a
Sir,
monthly
ये
rate
सब
of
हो गया. What was the plaint? What was the written statement? What are the foundational details? That is already over.
नहीं तो
आप
three
खाली इतना देखिए कि आपको रेंट एट द रेट ऑफ ₹100 पर मंथ, एरियर भी उसी 100 पर मंथ के हिसाब से दिया गया है. 300 पर मंथ के हिसाब से एरियर नहीं दिया गया.
नहीं दिया. Therefore
the fact stands admitted that you were paying rent till 21/8/97.
97 at the rate of 100 rupees.
That's right.
And it was as per the agreement that for holding the vacant land I would pay.
That was your case. That you were holding the vacant land and you were paying rent at the rate of ₹100 for the vacant land.
Mine. Because why I say that the plaintiff case is that para 3 also says further case of the plaintiff is that Narendra Prasad Sinha sold a portion of his said holding, including the premises, to the plaintiff by virtue of a registered sale dated 21/8/97 and was put in possession. That after purchase the plaintiff intimated the defendant through registered notice by his advocate so and so on 6/10/97 to pay the monthly rent at the rate of 300 rupees. So case of the plaintiff was 300 rupees per month. My case was as per the agreement I was paying 100 rupees holding charge. The court has found okay. It was admitted 100 rupees holding charge, you pay at the rate of 100 rupees holding charge. So that will not be for the building, that will be for the vacant land. This is my humble submission. Thereafter I have stated, but the defendant replied the notice through his lawyers on 18/10/97, and in the said notice defendant has denied from the relationship of landlord and tenant. It has also been denied by the said notice that he has made earlier agreement of the sale with Narendra Prasad Sinha to sell the suit premises for ₹15,000. It was also replied in the notice that he paid ₹5,000 as premium to Narendra Prasad Sinha for use of vacant land. That is the case of the defendant has been. It has been recorded in the judgment. The rent was to be paid ₹100. So it was for the vacant land. My lord. It was also agreed between the parties and Narendra Prasad Sinha that at the time of registration of the document, the money ₹5,000 given as premium shall be adjusted from the purchase price. It was also replied through the notice that some false allegations were made alleged against the plaintiff. The further case of the plaintiff is that the said Narendra Prasad Sinha on 22/8/97 intimated to the defendant regarding the sale of disputed premises to the plaintiff and had directed to the defendant to pay the rent to the plaintiff for the suit premises. In spite of receiving the notice dated 6/10/97, defendant did not pay the rent to the plaintiff from 21/8/97 to January 98. So he has defaulted in respect of payment of rent for more than 2 consecutive months, and he is liable to be evicted from the suit premises as defendant has denied the title of the plaintiff through the reply dated 18/7/97. So he has forfeited his right to continue a stay. Para 6, the case of defendant has been recorded as against the defendant has appeared and has filed his written statement. The defendant has submitted through his WS that suit is complete, is a complete example of dishonesty. These are words I don't want to spell. On the part of plaintiff and her husband, Uran Ram, this suit is not under the purview of BBC Act, but simply it is a suit for declaration of title. Plaintiff has also not come with clean hands such and such. The defendant has also denied from the relationship of landlord and tenant between the parties. The defendant has admitted that the suit premises had fallen in the share of Narendra Prasad Sinha through partition. These things are not relevant for this case. Further case of defendant is that said Narendra Prasad Sinha was ailing and was in need of money and was interested to lease out the vacant portion. To the defendant approached him and Narendra Prasad Sinha agreed to give vacant land for rupees 15,000, but before transfer of the said property, the property was leased out to the defendant for after getting 5,000 and it was also agreed that defendant will pay rupees 100 as rent to the plaintiff for vacant land. It was also agreed that at the time of the registration of the sale deed, rupees 5,000 given in premium shall be adjusted from the sold amount, which was rupees 15,000. In fact, not this 15,000, I checked up whether it was a very meager amount or what. But I have found that 11 years after, the larger area was sold at rupees 20,000 to the plaintiff. So I came to the conclusion that the amount 15,000 was proper and was the highest price on that day when the agreement for sale was entered. Reference to this agreement to sale is in very many words in para 7 of the judgment of the child court and thereafter by the further case of the defendant is that at the last stage of his life, the said Narendra Prasad Sinha was under clutches of his Fufa's son Ashok Kumar Sinha, and defendant in the month of July 97 requested Narendra Prasad Sinha to fulfill the contract of his part, and defendant also offered balance consideration amount, but due to pressure of said Ashok Kumar Sinha, the matter was deferred, and as Ashok Kumar Sinha himself was interested in deriving illegal benefit. So, my lord, readiness and willingness of the defendant has been recorded at para 9 of the child court judgment.
That is not the issue before us.
Huh?
That is not the issue before us. This is not a case arise. Sir, आपकी बात आप अपना substantial question of law क्यों frame होता है? The Supreme Court says that I cannot travel beyond the substantial question of law. Your readiness and willingness, your specific performance of contract. You did not file a suit for specific performance of contract, did you?
Right.
Then?
My lord will kindly consider the learned courts below have dealt this, whether there was readiness and willingness. Even the appellate court has dealt it.
It's immaterial.
Whether वो कभी offer किया कि नहीं?
It's immaterial.
Then we learned issues were framed. And issue number 3 was, is there any relationship of landlord and tenant between the plaintiff and the defendant? It is at page 26 of running page 26 of the brief one. Findings start from page 27.
Yes.
Plaintiff has also defendant have examined oral and documentary evidences. The witnesses examined by the plaintiff are the following: PW1 Purana, he is husband of the purchaser, plaintiff. PW2 Mohammed Munna, PW3 Munna, he was a convict, he had come after serving out sentence. PW3 Bodhilal Verma and PW4 Prakash Verma. The plaintiff has also filed certified copy of sale executed by Narendra Prasad in favor of Chintu Devi dated 21/8/97 along with map. The witness examined by the defendant are as follows: DW1 Raghunath Beldar, DW2 Mohan Kumar Gahlot. He is the writer of the agreement minor, and he has witnessed it also, and he has signed it also, and he is a witness. DW3 Om Prakash Kesri, he is the defendant minor, and DW4 Bhola Prasad Kesri. Para 15, the defendant has also filed an Iqrarnama dated 14/8/86, executed by Narendra Prasad Sinha in favor of Om Prakash Kesri, and have exhibited the same, which is Exhibit A. For the sake of convenience, issue number 3 is taken as first. Whether there is a relationship of landlord and tenant exists between the plaintiff and defendant. Further, we have to get through the evidences adduced by the parties. There are two of the plaintiff. The case of the plaintiff is that defendant was inducted as a tenant by Narendra Prasad Sinha on monthly rent of rupees 300 in the year 1985 for portion of holding number 373 old and 487 present, and as per para 2 of the the defendant came in possession as a tenant. So in 1985 at rupees 300 the defendant came in possession of the tenanted premises. It is as per the plain. As para 7 of the written statement, the case of the defendant is that he put structure over the portion leased out to him at his own cost and covered the roof with corrugated sheets in the year 1985. As per para 8 of the written statement, it is also a case of the defendant that Narendra Prasad Sinha began to realize rupees 100 for use and occupation of the land. Thus, as per the case of the plaintiff and defendant, it is admitted fact that there was relationship of landlord and tenant between Narendra Prasad Sinha and defendant with respect to the suit premises. So this observation is not beyond the pleadings, beyond the evidence. When the statement is that the rent was 300, whereas the defendant says I was paying 100, and for use of the land, the observation of the court that relationship of tenant, landlord and tenant between Narendra Prasad Sinha and defendant with respect to suit premises. Suit premises on the date of filing of the suit was a corrugated sheet room. The defendant the difference which remains between the parties is that whether the rent was 300 or rupees 100. So let this it makes the structural difference between the case of the parties. There is no case that the rent for the house was rupees 300 or 100. Case of the plaintiff was that premises, that is the rented premises, that is the rent for the structure was 300, whereas case of the plaintiff was defendant was that rupees 100 was for the use of the land. There is far-reaching difference. As para 4 of the case of the plaintiff is that Narendra Prasad Sinha had sold the portion of the said holding including the premises in suit to plaintiff through a registered deed dated 21/8/97. This fact has not been denied by the defendant specifically, and denial is of evasive nature. This is also incorrect. It was not evasive, it was very strict and straightforward that the 100 rupees were being paid for use of the land, not for the premises, not for the structure. As provided under Order 8-5 CPC, thus, what is provided under 8-5 CPC? I don't understand. That relates to pleadings. A special denial, every allegation of fact in the plaintiff, if not denied specifically or by necessary implication, or is stated to be not admitted in the pleading of the defendant shall be taken to be admitted, except as against a person under disability. Why not? This does not apply. Clearly it is stated I was paying 100 rupees for the use of land. There was no admission that I was paying rupees 100 for room or veranda or anything. As the provision of section so thus the statement made in paragraph 4 of the plaint will be deemed to be admitted. These are all, my lord, in my humble submission, in non-consideration of the facts of the case. This observation is far away from the facts of the case. Exhibit 1 executed by Narendra Prasad Sinha in favor of plaintiff stands admitted. Now, my lord, execution of sale deed, Exhibit 1 by Narendra Prasad Sinha is not admitted. That is their case that I have purchased it. They may say, and I have checked up in the last evening manner, that this sale deed was for a particular land given in the schedule therein, which does not tally with the schedule of the plaint. In the sale deed, there is road on two sides, on east side and on south, whereas in the plaint something different is written. How it will be executed? As per the sale deed, the land is somewhere else. The suit has been filed for a land which does not tally with the boundaries given in the plaint, boundaries given in the sale deed.
Sir, you continue your argument. ऐसे बीच में break मत करिए.
I thought my lord is noting down.
हम
this.
सब चीज note कर रहे हैं.
अच्छा अच्छा ठीक.
आपका हर argument हम note कर रहे हैं.
My lord, my lord, my lord. Now the learned trial court, my lord.
एकदम ब्रेक मत दीजिएगा. हम एकदम कंटिन्यूअसली आपका हर आर्गुमेंट रजिस्टर कर रहे हैं.
अच्छा.
है ना? आई डोंट वांट अ ब्रेक.
My lord, my lord. While dealing with, my lord, the issue number 3, whether there is a relationship of landlord and tenant, I am reading from page 27, my lord, findings. Paragraph 16. The tenant.
आप खाली relevant portion पढ़ सकते हैं.
हाँ.
You have already read the entire text almost.
Yes.
Right? खाली relevant portion mark करेंगे.
हाँ.
Trial court में. Trial court का
Trial.
judgment.
But at page 32, internal page 10 of the trial court judgment, seven lines from bottom, it has also been argued. Page 32. May I proceed?
Yes.
It has also been argued that defendant is in possession of the suit premises in part performance of contract alleged to enter into between Narendra Prasad Sinha and defendant. The defendant has not disclosed the date of alleged agreement. However, my lord, 14/8/86 is recorded in the exhibit A itself. That is part of the court's record. It has also not been disclosed that why the agreement in question was reduced in writing on 14/8/86, because that was the date when the agreement was entered.
You pleaded. Your case was that the agreement was entered into at the time the suit premises was given to you.
Yes.
So in the year 1985.
86, not in 85.
Suit premises was handed over to you in the year 1985, and you also deposed that the agreement was simultaneously entered.
My lord,
So if the agreement was simultaneously entered, the court is recording a finding. There is no explanation as to why it was reduced into writing in the year 1986.
yes. My humble submission is, my lord, to this is that 85 to 86, I may be a tenant at the rate of 300 rupees per month, but
That is not your case.
No, not my case.
Then,
The case the plaintiff has to win or lose.
so
Decree will be given to
you
him
see,
or he will lose
when
the case.
we are referring to Exhibit A,
Huh.
we would like to see your case because
Yes,
that is your
yes.
document.
Yes,
That is not your case. That is why the court is saying that this particular document of the year 1986 is a subsequent recording of certain agreement, but the date of the agreement has not been mentioned in that document. And you were saying that the date of the agreement is mentioned.
it is embedded in the agreement
No,
itself.
therefore it
This
is
is my humble submission.
your specific case was that at the time of entering into the premises,
Yes.
you entered into an
Yes,
agreement.
I did not enter into any premises. I took the land.
That's right. Whatever be the premises,
Huh.
premises could be land, it could
Yes.
be land and building, it could be only building.
It was only land, and it was for agreement for sale, and rupees 100 was being paid for use of the land until the same is taken on purchase by a registered seller. It has not been disclosed that why the agreement in question was reduced in writing on 14/8/86, of course, for purchasing the land. As per living in, it is admitted the defendant was inducted as a tenant in the year 1985. That is case of the plaintiff. He may prove it. He has failed to prove. He has utterly failed to prove that in 85 I was a tenant. I will show it from the evidence of Gahlot.
It was your case that you were a tenant since 1985
My lord,
at the rate of rupees 100 per month of the land.
86 से
85 से written statement आप देखिए para 8.
पैरा देखिए Para 8 I am permitted to read that Narendra Prasad Sinha alias Gurulal Sinha as such entered into a concluded contract for sale of the suit premises on the defendant, premises to the defendant on a consideration amount of rupees 15,000, and in the meanwhile till the sale is materialized, Narendra Prasad Sinha began to realize rupees 100 per month for use and occupation of lands as rent from the defendant.
7 भी पढ़े.
जी?
7.
Sir, that the defendant put a structure over his portion leased out to him at his own cost and covered the roof with variegated sheets in the year 1985, which is still in existence. Hence, it is far from truth to contend that the suit premises is
85 में आपका एंट्री है ना.
हाँ,
तो बस इससे आप इस पे डिनाई नहीं कर सकते हैं कि आपका जो भी बी टेनेंसी ऑफ द प्रेमिसेस बी टेनेंसी ऑफ द लैंड
land.
बट 100 रुपीज पर मंथ
हाँ,
was given
Given.
with effect from 1980. इसमें तो ये तो आपका एडमिशन है. तो
Sir,
इसीलिए जो आप
मैडम-
बोल रहे हैं कि ऑर्डर 8 रूल 5 का जो
नहीं, हमने बोला,
आपका
कोर्ट-
डिनाइल ही नहीं है.
नहीं।
कोर्ट बोल रहे हैं, कोर्ट जो बोल रहे हैं
कोर्ट-
जिसको आप असेल कर रहे हैं, this is an admitted fact on record that you entered into the premises in 1985 paying rent at the rate of rupees 1.
my-
The point is whether there was any structure or there was no structure,
No.
and even if it is assumed that the structure came later on,
Later.
what is the impact?
What is
बस इतना ही सा तो पॉइंट है. इसके अलावा कुछ पॉइंट ही नहीं है. इतना
नहीं.
पढ़ने का कोई काम ही नहीं है.
yes, my lord?
बस अब 10 मिनट में अपना पॉइंट एकदम पिन पॉइंट करके अपना आर्गुमेंट्स कंक्लूड करें. आई हैव हर्ड यू फॉर 1 hour और आप अभी तक मुद्दा पर नहीं पहुंचे. इतना लेजरली हम लोग नहीं सुन सकते.
ये तो प्लेन का मैटर.
आपको बिना डिस्टर्ब किए सुने हम आपको. हाँ, बस आप मुद्दे तक पहुंचे ही नहीं अभी तक 1 घंटा में भी.
Now look, admittedly, there is a agreement for sale on 14/8/86. The court also finds that
कोर्ट हैज डिसबिलीव्ड इट एंड रिकॉर्डेड सर्टेन फाइंडिंग्स ऑन दैट. इसलिए एडमिटेडली कुछ मत बोलिए. जो आपको बोलना है आप रिकॉर्ड से बोलिए. एडमिटेडली कुछ नहीं होगा. दैट वाज योर केस. एडमिटेडली नॉट एडमिटेडली इट्स अ सेपरेट थिंग ओनली.
Now let I may be permitted to come to the appellate court judgment.
there is a concurrent finding on appreciation of materials on record that there existed a shop in the year 1980 in a dilapidated way. And no substantial question of law has been framed with regard to this concurrent finding. And on the face of the concurrent finding, be it dilapidated condition, be it a full-fledged
doesn't
condition,
make
that
any
makes no difference.
Makes no
So there is
difference.
no substantial question of law on this finding.
Well, my
Then under such circumstances, how can you come out of this finding and say that there is no tenancy under the BBC Act?
Yes. My lord, my humble submission is that on 14/8/86, the agreement for sale was executed.
That is not a gospel truth. That is a sada agreement entered into with the ex-landlord.
It is on record of the case.
So we have to see the evidences, the entire material on record.
My lord,
Why only Exhibit A has to be seen?
no. My humble submission is that the tenancy from 85 came to a grinding halt. It ceased to exist upon execution of the agreement to sale because the relationship.
Why did you pay the rent post 86?
Yes, my lord.
Why did you pay the rent post 86? Because you, in the agreement itself, it was written.
Yes.
So therefore, part performance of the agreement, etc., will have no role to play. There are two situations. One is there is an agreement for sale.
My lord,
One is there is an agreement for sale, and after the agreement of sale, the party is put in possession of the property, and
My
it is agreed that no further rent will be paid.
Yes.
Right? It is not the case here.
My lord, my humble submission is that the execution of the agreement to sale culminated the previous relation of landlord and tenant.
But you continued to pay the rent, isn't it?
It was not word may
As
be
per
used.
the, what do you mean word may, as per the agreement itself, it is mentioned
Yes,
that you will continue to pay
I
the
will be
rent.
permitted to read the agreement, my lord.
टेनेंसी आपका खत्म नहीं हुआ सर.
My lord, हमने लिखा है,
टेनेंसी अगर खत्म हुआ तो 100 रुपए महीना क्यों दिए?
हाँ दिए जमीन के यूज
क्यों देंगे आप? एक ही बात है ना.
हैं?
It makes no difference.
My
It
lord,
makes no
it
difference.
will-
The property, the structure was already
Actually,
existing on the
Probably
agreement.
I am not clear, my lord.
I'm absolutely clear. आप
No, no, probably I am not clear.
I understand what you are asking.
I may be permitted to refer to a judgment which I have yesterday placed for my
उस judgment को आप place करते हैं.
हाँ, 2000 volume 9 SCC, place 339. I have given a copy to my learned friend also.
Yes, it is.
जी. Relevant is at page 6, 7 and 8.
सर बिना फैक्ट के केस मत करिए. फैक्ट पढ़िए.
जी, fact
Very
one.
fact.
हाँ, ठीक है. Third line counsel for the parties. The question raised in appeal is an interesting question and of some importance. The question is whether on the execution of agreement of sale by the landlord with the tenant and landlord having received a substantial portion of the sale consideration, the relationship of landlord and tenant intercede between them ceases and fresh rights and obligations flow under the act. The present appeal is by the tenant who received decree of eviction against him by the order of the trial court confirmed by the appellate court authority and finally affirmed by the high court. The respondent landlord filed a suit for eviction on the ground of willful default and also of committing an act of waste under section so and so of the Tamil Nadu Building Lease Rent and Control Act 1960. Her case is that though the tenant paid rent regularly up to March 1977, but thereafter did not pay rent regularly, but on request of the appellant, tenant to the landlady, she agreed to sell the disputed premises. As a consequence, the agreement of sale was executed on 4/5/77. According to the landlady, a breach was committed by the appellant. Hence, she repudiated that agreement by returning the amount she received under it and then she filed a suit for eviction against the tenant. It is not in dispute that in terms of the said agreement, the total sale consideration was rupees 25,000. Out of this, the tenant paid rupees 20,000 to the landlady. On the date of agreement itself, the balance of rupees 5,000 remained to be paid on the date of registration of the sale. Relying on the agreement of sale, the appellant's case is that on its execution, the relationship between the respondent and the appellant changed. This word has been used, but the relationship between the respondent and the appellant changed. They no more remained a landlord and tenant. Hence, the present petition for eviction under the aforesaid act is not sustainable. In the alternative, it is submitted. In any case, non-payment of rent for this period cannot be construed to be a willful default within the meaning of section 10 of the said act. The rent controller and appellate authority both rejected this contention of the tenant and held that the tenant committed willful default, which was confirmed by the High Court. As aforesaid, the question for consideration is whether the status of tenant as such changed on the execution of an agreement of sale with the landlord. It is relevant at this juncture first to examine the terms of the agreement. The relevant portion of the agreement of sale record the following. I, the aforesaid Mrs. Beatrix Xavier, hereby agree out of my own free will to sell, convey and transfer the property to you, Mrs. R. Kanthimati, wife of Mr. S. Ramaswamy, 435 Tiruchi, Coimbatore, for a mutually agreed sale consideration of rupees 25,000. I shall be proceeding to Coimbatore and shall execute the sale deed and present the same for admission and registration before the registration authority, accepting the acknowledged payment of the balance of the consideration of rupees 5,000 at the time of registration, and shall complete the transaction of sale and conveyance as the property demised has already been surrendered to your possession. Submission for the tenant is after entering into the agreement, the landlady accepted rupees 20,000, confirming delivery of possession. In this context, which already constitutes the clear intent of the landlady of entering into a new relationship
With
with the
this
tenant.
factual background, you have referred to para 8 of the judgment. That's right.
Para 6, 7, 8.
6, 7 is the quotation, basically 7 is the quotation of earlier judgment.
Mara. 8 is this decision clearly spells out that once there is agreement of sale between a landlord and a tenant, the old relationship as such comes to an end.
That's right.
It goes on to record that even after the cancellation of the said agreement of sale, the status of tenant is not restored as such.
That's right.
In other words, on the date of execution of the aforesaid agreement of sale, this status as that of landlord and tenant changes into a new status as that of purchaser and seller.
That's right.
This is the question.
The learned counsel for the appellant, while referring to the substantial question of law number A, has submitted that on bare perusal of exhibit A, which is dated 14/8/1986, it is apparent that there was an agreement of sale with respect to
May I take this?
the vacant land at a consideration amount of rupees 15,000, out of which 5,000 was already paid. It is not in dispute that the defendant was in possession of the property. The learned counsel submits that the agreement of sale reveals that it was a vacant land, and therefore the provision of Bihar Building within bracket Lease, Rent and Eviction bracket close Control Act 1982 was not at all applicable. The learned counsel submits that both the learned courts have failed to consider the agreement of sale properly, which was an agreement for sale of vacant land, and what was being paid was the rent of vacant land at the rate of rupees 100, and it was not rent for any building or constructed property over the land, and therefore on the face of the agreement exhibit A, the eviction suit was not maintainable under the special law of BBC Act. With respect to second substantial question of law, the learned counsel for the appellant has submitted that once the agreement of sale was entered into between the parties, the relationship of landlord and tenant between the ex-landlord Naren Prasad Sinha and the defendant ceased to exist, and therefore merely on purchase of property by the plaintiff through a registered sale deed of the year 1997 could not have revived the alleged relationship of landlord and tenant between the defendant and Naren Prasad Sinha. Rather, the plaintiff was holding the property, the defendant was holding the property by his own right. For this, he has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2009, bracket close 9, SCC 339, and has submitted that in the said case, the agreement for sale was entered into between the parties, and it was ultimately held that upon entering into agreement of sale between landlord and tenant, the relationship of landlord and tenant comes to an end. He submits that had the courts considered Exhibit A properly, there could not have been any other conclusion that the relationship of landlord and tenant between Naren Prasad Sinha and the defendant had come to an end by virtue of agreement of sale Exhibit A, and therefore even by virtue of purchase by the plaintiff, there was no continuation of relationship of landlord and tenant. यही है? That's all? बताइए आपको.
Lord, so far as the first substantial question of law is concerned, Lord, both the courts, trial court as well as the appellate, taking into consideration the evidence of DW1, has concluded that in the year 1985 itself, there was followed tuta-futa room, and there was already a room, tuta-futa room, Hence, my lord, so far as the maintainability aspect your lordship is concerned, both the court have concluded that the very eviction suit itself was maintainable. The relevant paragraphs your lordship I will want. My senior friend my lord has already read out, so I won't take that much time. But just my lord, if the cause of action is suit is maintainable, that is issue number 2.
Yes.
Issue number 1 and 2, your lordship, the learned trial court has dealt in para 21. And my lord has concluded, taking into evidence of my lord DW1, that नालसी जमीन पर टूटा फूटा घर था, उसी का मरम्मत मैंने किया. This statement goes to show that the constructed room let out the defendant was not evicted. This is what is his case. And accordingly, relying further that it was entered in 1985, and as per his case, that same was reduced in writing on 14/8/2006. There is no explanation. So that part has also been taken into consideration, and that Exhibit A itself has been dealt with. And has come to a finding that he was a tenant, as because there is an admission that he was making payment of rent to Narendra Kumar Sinha itself, and subsequently when the verdict was disputed in the favor of the plaintiff, then all the rights etc. were transferred, including the tenancy etc. Narendra Kumar Sinha himself has noticed him.
So that atonement is not required.
Not
Those are
required.
not the issues before us.
And it is also not required.
That is not the issue before
That
us.
is not also issue.
That is not the substantial question of law. His entire case is that the relationship ceased in 1986 itself,
Yes.
and therefore
1986.
1986 by virtue of the agreement, and therefore there was no relationship of landlord and tenant even between the defendant and Narendra Prasad Sinha post 1986.
That's what he is saying.
That's what he is saying.
But both the learned court, so far as the maintainability aspect of the thing is concerned, has come to a finding that it is maintainable. So this is a concurrent finding of fact. So far as the second substantial question of law is concerned, that whether the learned court below failed to consider and hold that the relationship of landlord-tenant did not exist between the plaintiff and vendor, alias Narendra Prasad Sinha, Buddhu Lal Sinha, appellant under the Act. Failed to consider and hold that the relationship.
This is what he is saying, that they have failed to consider that the relationship itself did not exist of landlord and tenant between Narendra Prasad Sinha and the defendant.
But
This is the meaning of
that
this.
is the concluded finding that on basis of the
There are
admission.
two things. One is the relationship of landlord and tenant
Yes.
under the BBC Act.
Well,
Had there been a construction, it will exist, and had there been no construction, it will not be guided by BBC
Yes.
Act. This is one aspect. Second aspect is that whether after the entering into agreement, the relationship existed or it did not exist, because they have relied upon this judgment that if there is an agreement of sale between the landlord and the tenant continues to remain in possession of the property, then the relationship ceases to exist.
that is what he is.
This is what he has said, and this is what the judgment is. So you just tell us, and this judgment is also referring to the interpretation of the agreement, because agreement is required to be seen.
Yes.
It is not just any agreement entered into. The agreement is required to be seen. You have got Exhibit A.
Exhibit A.
उनको दीजिए सर Exhibit A दीजिए. पढ़िए आप Exhibit A, because interpretation of Exhibit A would be relevant.
That part has been taken note by the appellate court. Appellate court has said that this agreement event the signature of Narendra Prasad Sinha has not been.
No, that is, we are not on whether Exhibit A has been proved or not. Exhibit A is there on record,
Yes.
right? Now you tell us that what is the, you just read Exhibit A.
Yeah. मैं नरेंद्र प्रसाद सिन्हा, बुद्धूलाल सिन्हा व राधिका प्रसाद सिन्हा, मुस्मात शाकिन दर्जी मोहल्ला, काली मंडा रोड, गिरिडीह, इकरार करता हूँ कि मेरी ऐसी खाना के मकान के पूर्व तरफ जो मेरी खाली जमीन सड़क को किनारे है जिसका होल्डिंग नंबर सच है के अंदर 1.5 फीट लंबा और 8 फीट चौड़ा जमीन को बिक्री का बातचीत 1500 रुपये में ओम प्रकाश 15,000 रुपये में ओम प्रकाश के सच के साथ की है। इसके अंदर बतौर पेशगी को 5,000 रुपया मैंने पाया और गठा खास जमीन पर ओम प्रकाश केसरी को दिया। अब वो ओम प्रकाश केसरी जमीन पर अपने खर्चे से दुकान बनाकर चलाएंगे और जब तक जमीन का केवाला नहीं हो जाता है मुझे 100 रुपये के प्रतिमाह के उपयोग के लिए दिया।
So rent was continued to be paid in spite of this agreement.
Yes, and he has paid it.
He has paid it.
Yes, so there is the relationship which was already occurring is continued.
He has paid it till 1997. Admitted fact.
Yes,
Yes, with the
yes.
police paid.
So far as the tenancy is concerned, despite having this document, there was the landlord-tenant relationship continued. So no juror relationship it was created. And apart from that, my lord, they did not file any suit for a specific performance of contract. There is no, my lord, in furtherance of contract, there are judgments to that effect, my lord.
There is no overtime.
No what?
53A का केस ही नहीं बना है।
और that aspect
53A का ना केस बना है, ना क्वेश्चन ऑफ लॉ है, ना ही वो प्रूव हुआ।
हाँ नहीं, और वो केस इनका नहीं बनता है। तो उस पर्टिकुलर कंडीशन में ये एक ही केस बनता है कि whether there is a landlord tenant relationship or not।
इसमें तो कोई टाइम टेबल भी नहीं है कब करेंगे। एग्रीमेंट ऑफ सेल कब करेंगे, कोई टाइम टेबल नहीं है।
इन फर्दरेंस ऑफ कॉन्ट्रैक्ट की कोई नहीं है। अगर
इसमें ये भी नहीं है कि इतना दिन में करेंगे, ऐसा कुछ है
होल्डिंग नंबर निकालते कुछ
नहीं है, कुछ नहीं है।
ये एग्रीमेंट जो है इट इज अ सादा
इट इज एन ओपन एग्रीमेंट फॉर इन परपेचुइटी।
और इन परपेचुइटी
In perpetuity because it does not have a timeline also.
That timeline also.
It does not.
और apart from that, इन्होंने कभी भी उनको कोई नोटिस भी नहीं दिया कि आप इसको डिस्प्यूट करिए या कोई स्पेसिफिक परफॉर्मेंस ऑफ कॉन्ट्रैक्ट इन फर्दरेंस ऑफ कॉन्ट्रैक्ट कोई अदरवाइज इसको रिमूव करते हैं। तो इसलिए ये इसके आधार पर इनका प्रोटेक्शन ट्रायल कोर्ट ने और एपेलेट कोर्ट ने राइटली प्रोटेक्ट नहीं किया। So far as the landlord tenant relationship is concerned, it is an admitted fact। और जो जहाँ तक का सेडिट का बात है, वो जो 8 रूल 5 जो कोर्ट ने रिलाई किया, that is with respect to सेडिट, उसका स्पेसिफिक डिनाइल नहीं है कि there is no सेडिट। तो इसमें ये 8.5 रूल 8.5 जो पढ़ रहे थे, वो आप दोबारा से पढ़ लेते हैं। उसमें 8.5 का ऑर्डर 8 रूल 5 का वो कह रहा है, उसका कोर्ट का कहना ये पढ़ देते हैं।
ट्रायल कोर्ट एपेलेट
आप ट्रायल para 6 पढ़ा, पेज 6 इंटरनल पेज 6 देखा। मिडिल से हम पढ़ रहे हैं और जो रेंट वाज 300 और 100 वहां कंक्लूड हो गया। हाँ उसके बाद फर्दर पढ़ते हैं। As para 4 of the plaintiff case of the plaintiff is that Naren Prasad Sinha had sold the portion of said holding including premises in the suit to the plaintiff through a registered sale deed dated 21/8/97। This fact has not been denied by the defendant।
it exhibit भी हुआ registered sale deed, this has been exhibited।
yes एक हमारे
exhibit भी हुआ,
exhibit भी हुआ, इसको डिनाई भी नहीं किया। वो अब उसके रेस्पेक्ट में कोर्ट ने कहा है कि आपका कोई स्पेसिफिक डिनाइल नहीं है। when there is a specific denial नहीं है, अगर आपका evasive denial है, that amounts to admission that what is the order 5
this fact।
तो वो जो रेंट के पार्ट पर नहीं है, वो एक्चुअल में एग्जिबिट 1 के पार्ट। ये इसके अलावा जो है जो so far as this judgment is concerned, which my senior counsel learned senior counsel in the line, facts are different here। It is not the same facts। It's not the same facts।
The learned counsel for the respondents, while referring to first substantial question of law, has submitted that both the courts considered the evidences on record, particularly the evidence of DW1, who has stated that on the basis of which it has been concluded that in the year 1985 itself, there was a room over the premises, but the room was in a dilapidated condition. The learned counsel has referred to paragraph 21 of the trial court judgment relating to issue number 1 and 2, and has submitted that every aspect of the matter has been considered while deciding the maintainability of the suit under the BBC Act,
Which has been affirmed by the appellate.
which has been affirmed by the learned first appellate court. The learned counsel has also submitted that since the suit land way back in the year 1985 itself was not a vacant land, and having a structure thereon, therefore the provision of BBC Act was clearly applicable, merely because in Exhibit A, there is a mention of vacant land. The same is not a conclusive proof. Exhibit A by itself is an unregistered document.
And there is no mentioning regarding any entry back in 1985.
He has also submitted that there is no explanation with regard to entering into agreement in the year 1986, though as per the case of the defendant, it was agreed way back in 1985 itself that the suit land will be sold to the defendant.
Entry with respect to 85, it was
Achha,
given for
yes.
for the tenancy purpose.
Okay. एक चीज इसको last sentence है. The learned counsel has submitted that in the agreement of the year 1986, there is no mention about the creation of tenancy in the year 1985. Although the plaint and the written statement clearly demonstrate that it stood admitted that tenancy was created way back in the year 1985 itself. With respect to second substantial question of law, the learned counsel has submitted that the agreement of sale is required to be construed in order to come to a finding as to whether the relationship of landlord and tenant terminated upon entering into agreement of sale. He has further submitted that as per the agreement itself, the liability to pay rent at ₹100 per month continued. He submits that in such circumstances, it cannot be said that the tenancy between Naren Prasad Sinha and the defendant discontinued upon entering into agreement of sale. The learned counsel has submitted that so far as the plea regarding part performance of contract under section 53 capital A is concerned, the same has been rightly rejected by both the courts. He has submitted that on bare perusal of Exhibit A, there is no timeline given for entering into the agreement between Naren Prasad, entering into sale deed between Naren Prasad Sinha and the defendant, and at no point of time the defendant filed any case for specific performance of contract. He submits that had the defendant filed any case for specific performance of contract, the same would have failed, as the basic ingredients for satisfaction of specific performance or suit for specific performance of contract was itself missing by Exhibit A. He has also submitted that no substantial question of law has been framed with regard to specific performance of contract or with regard to part performance of contract under section 53 capital A of the Transfer of Property Act. He submits that findings in that connection stands concluded between the parties. That's all.
So far as this judgment,
The learned counsel has, so far as the judgment relied upon by the learned counsel for the appellant reported in bracket 2009, bracket 2000, bracket close 9, SCC 339, the learned counsel has submitted that the judgment itself says that the agreement between the parties is required to be considered, and he has submitted that there cannot be a straight jacket formula that merely because the agreement has been entered into that would end the tenancy between the parties.
And because the payment was made subsequently also.
The learned counsel has submitted that it is not in dispute that the defendant continued to pay rent at the rate of 1,000 till the sale deed was executed at the rate of rupees 100 per month till the sale deed was executed by Naren Prasad Sinha in favor of the plaintiff.
So no dual relationship as such with the appellant is claiming actually it was created in this case.
He has submitted that no new dual relationship has been created. It was the existing dual relationship which continued after the purchase of the property by the plaintiff. ठीक है? पंकज जी आप इसको लिखिए, कोशिश करते हैं कि शाम तक हम आपको जजमेंट दे दें. इन केस नहीं होगा तो कल आपको जजमेंट आएगा. आर्गुमेंट्स कंक्लूडेड.
इसमें एक चीज और दिखाना, my lord permits. The evidence of the plaintiffs concluded on 26/4/2001,
So
and the exhibit 1, the sale deed, was reduced by way of a certified copy, not the original, after 3 years.
सर ये
in
सब
2004.
there is no scope. आप
Number-
substantial question of law के आगे beyond नहीं जा सकते ना सर.
And number 2,
Whatever
my
be the
lord,
date.
the schedule of the property given in the sale deed is different than the schedule of property given.
ऐसा substantial
In the
question
play.
of law नहीं बनवाए हैं सर,
ठीक है।
इसीलिए उसके उसमें हम नहीं जा सकते. अब जाइए पंकज जी.
उसमें क्या नेक्स्ट डेट मतलब टुमारो करेंगे या फिर आज का?
अभी हो सकता है 4 बजे pronounce
अच्छा ठीक
पॉसिबल है. आप इसको करिए. Have your lunch before I leave.
Public.
इसको रख लेंगे प्लीज.
From daily list, under heading for final disposal, item 2, second appeal 402/2016, along with item 3.
फिर से किताब आया है. दो तीन कुछ क्वेश्चंस हैं on facts. Please clarify those questions. If it is available on record, it's good. Or if it is not available on record, you just let us know. क्योंकि किसी का डेट ऑफ डेथ वगैरह अवेलेबल नहीं है, तो हम जानना चाहते हैं कि किसका डेट ऑफ डेथ.
ठीक.
कॉमन एंसेस्टर का डेट ऑफ डेथ अवेलेबल है.
नहीं.
कॉमन एंसेस्टर का नाम क्या था? गुड्डू को.
Gudru. Gudru. Gudru.
डेट ऑफ डेथ नॉट अवेलेबल. उनकी वाइफ का
Only referred to as first wife and second wife. No name is mentioned. And you know, both the parties, it is not their case that any of the wives were entitled to any share. So that is not a question. No
so
date
date of death
of
is
first
also
wife
not
or
available.
second wife not.
एक चीज और, the property has been held to be ancestral property.
Yes. Ancestral property means the property acquired by Gudru.
But after his death, it becomes ancestral.
Yeah, ancestral, that would be one of the questions.
ऐसा कोई क्वेश्चन ऑफ लॉ तो नहीं बना है?
नहीं है. I'll show why.
Any property acquired by father after his death,
Acquired by
father after his death, partakes the character of ancestral property and becomes a co-pastoral property.
any property acquired by the parties.
No, by the father. And upon his death, the status of the property becomes ancestral property so far as his sons are concerned.
So only sons are.
Only sons are
Yes,
concerned.
yes.
Right.
So if
And even for the daughters as of now,
yes.
they are not concerned.
So that is not that question is not there. Therefore, I'm not going.
So these are admitted facts that it became.
Admitted fact is that Gudru Gop had acquired
That's
property
right.
and he died leaving behind 4 sons.
That's right.
4 sons, the property devolved on them, and then thereafter 2 sons died.
No, I just want to know, is there any date of death
No,
of 2 sons?
no.
Is there any previous partition?
No. Although we had claimed, but this was denied by. Ultimately, it was held that it is a.
There was no previous partition.
There was no previous. And that order attained finality, Your Lordship, because we were claiming on the basis of a previous partition.
That's
Then that suit was dismissed, and then appeal, as I had disclosed, that appeal was also dismissed. In second appeal, the matter was remanded to the first appellate court, but we did not take
so
any
as
steps.
of now, there is no story of previous partition.
No, it couldn't. Although we are saying that
But
because
considering the substantial
Yes,
question of
yes.
law, there is no story of any previous partition.
No, because we are also saying that they had transferred several properties in which they had said about previous partition. But Your Lordship, ultimately, because the suit in which I was claiming on the basis of a previous partition, that was dismissed, and it was not set aside by the higher court. I cannot rely on the.
That's right.
So
So
that-
that finding is there,
Yes.
that there is no previous partition.
Yes.
This is the first appeal.
Yes.
Now the point is that there is no finding that one or the other, the children born out of second wife, they are illegitimate child. There is no finding. इसको लिखिए तो जरा. The name of common ancestor of the parties was Gudruko, whose date of death has not been placed on record. He had 2 wives. They have been termed as first wife and second wife. However, their date of death has also not been placed on record. There is no finding that the children born out of second wife, children born out of wife termed as second wife were illegitimate children. It is not in dispute that 2 sons of first wife had expired, but the date of death of 2 sons of the first wife is also not available on record. It is not in dispute that the property was acquired by Gudruko, and upon his death it became ancestral property. The story of previous partition has been denied by the learned court, and such finding has attained finality, as no substantial question of law has been framed concerning previous partition.
Yes. So again, coming back to that question, Your Lordship, what would happen where we have to go back where the Gudrugo died, and immediately upon his death, the property would devolve. What would happen? Why, Your Lordship may again take up, because even if there was no date of death, then also the same law stood prior to 1956 also. So if the same law stood prior to 1956 and by it has subsequently been introduced in 1956 Act, then the same law that the full blood would be preferred over the half.
So therefore,
Yes.
when we talk about devolution of property of Gudrugo,
Yes.
his full blood or his half blood are not claiming,
No.
right?
No.
Who are claiming are the descendants of Gudrugo.
Yes.
And had his full blood claiming or his half blood claiming with respect to his property, suppose he died issueless and there was a issue of succession whether his full blood would get the property or his half blood would get the property, then I think section 18 would come into play that his full blood will get the property. But in a case where there is no partition and the property remained a joint family property, then the property will devolve by survivorship.
No. Therefore, this is the question Your Lordship may kindly see. Now, what would happen? My argument would be that it was a property of Gudrugo acquired. It was not ancestral in his hand. So once he died, so therefore, few of the provisions of Hindu law, Your Lordship may see. What happens is, Your Lordship, clause 28 is inheritance is never in abeyance. That means once a person dies, immediately it devolves. It is not kept in abeyance of a subsequent preferential
There is
heir.
nothing on.
I'll
There
come
is
to that.
nothing
I'll
on material.
come to
No,
your
no.
Lordship.
Just a moment. There is nothing on material as to when did he die,
Yes.
when did his wife die, when did the 2 children die. It is not on record.
It is not required. Therefore, I say it is not required. Had it been a case where the question whether the Hindu Succession Act would apply or old Hindu law would apply, then this question would have been material, where date of death would have changed the succession. The old law also says the same thing and the new law also same thing. So therefore, first thing which I wanted to point out, the moment Gudrugo dies, immediately all the 4 sons in the property devolved on all these 4 sons. So what would be the nature of the property?
It will come to all the 4 sons only when all the 4 sons were living.
Yes, they
If
were
2
living.
of them.
No, they were living. That is
Not
the
so.
statement of the plaintiff
When did he
himself.
die?
That
After
is-
his death
yes.
or before his death?
After his death. That is the statement of the plaintiff himself. That Your Lordship may take into account. I'll
2
come to
sons
them.
from first wife.
Yes. That is recorded in the board. In their
Expired
case.
after death of Gudrugo.
Yes, absolutely.
Did
Your
you know?
Lordship may see.
It is also not in dispute that though the date of death of 2 sons has not come on record, but it stood admitted from the side of plaintiff that 2 sons of Gudrugo expired after the death of Gudrugo.
Why I say Your Lordship may kindly take up the claim. This is
Yes,
important.
are you disputing this? Are you disputing this? That 2 sons who died, they died after the death of Gudrugo.
But there is such nothing on record. How my friend is saying.
Show us, please.
Your
Show
Lordship
us.
may see the claim. Para 2.
You have got the plaint?
Yes.
Mr. Sharma? Yes,
Para 2.
Yes.
That Gudrugo had 2 wives. Gudrugo had 2 wives. From the first wife, he had three sons, namely Gidhari Gop, Bhondu Gop, and Mithu Gop. But latter two sons died issueless, and their branches were extinguished, and their share devolved upon Gidhari Gop, who thus became shareholder to the extent of 8 annas from the second wife. Mithu Gop had one son, namely Bhola Gop, who became co-sharer of 8 annas share. He died leaving behind 4 sons, namely so and so, so and so. And then,
Who died leaving behind 4 sons?
Who
Who died leaving behind 4 sons? Gudru Gop?
Gudru Gop had one son, Bhola Gop, who became the co-sharer of 8 annas. He died leaving behind 4 sons. He means
Acha.
the second.
Bhola Gop.
Bhola. Yes. Then all other deaths are mentioned. Then your Lordship may see para 4. Thus, after the death of Gudru Gop, his said sons jointly inherited the properties of Khata number 7, which became their ancestral joint family in the hands of Girdhari Gop and his brothers and Ula Gop, and each having half share, they were governed by so much. So here, plaintiff himself says that it is the sons, they are not predeceased Gudru Gop.
It's not very
No,
clear.
no, no.
It is not very clear.
Not very. Nothing like that.
It is not very clear.
They would have said that
Let's
they
read
are
it slowly.
predeceased.
Let's read it slowly. Does Gudru Gop had 2 wives? Can you read it?
Yes.
From the first wife,
From the first wife, he had 3 sons, Girdhari Gop, Bhola Gop, and Mithu Gop. But latter 2 sons died issueless.
when?
No date has been.
No date.
But your Lordship, this has never been in dispute.
No, because when we are talking of succession and inheritance, whether they predeceased Gudru Gop,
So they would
that
mention,
becomes material.
yes, then they would mention that they had predeceased. They themselves say latter they died.
And they
They
died
do not even
issueless.
say that he had predeceased. The word predeceased would be there. That he had died leaving behind only 2 sons because they had predeceased.
In the written statement, what statement should come?
What is there in the written statement? And
Yes.
is there any finding to that effect? Is there any finding to this
I'll
effect?
come to that, your Lordship.
The finding is that there is no date of death, etc.
Just a moment. You just see para number 13.
Yes. Gudru Gop during his lifetime divided properties in equal 3 shares. 1 chance share to Girdhari Gop was allotted, and 2 shares to 3 brothers of Girdhari Gop and Bhondu Gop and Mithu Gop, sons through first wife, and 1/3, that is 1 share to Bhola Gop through the second wife, and they continued in possession accordingly. 3 brothers Girdhari Gop, Bhondu and Mithu lived in reunion while Bhola lived in separation.
So therefore, as per the written statement, during his lifetime, this Gudru Gop had divided the property.
Yes. And they were alive. They are not predeceased. Your Lordship may then see para 14. After the death of Gudru, the defendant Bhola Mahato created nuisance. Purchase were called so and so to resolve the dispute, and they, in approval of the partition held between them, amicably settled on the same right and prepared a memorandum of the
So
same.
after his death, the memorandum was prepared And thereafter, these two brothers died.
Yes. After the death of Mithu Gop and Bondu Gop, the sole surviving brother, Dedari succeeded. This is our state. So, and there is absolutely no statement by the plaintiff that the two sons had predeceased. Predeceased word would obviously come whenever they say that because he had predeceased, therefore the only two surviving sons were there, and therefore the property would divide half. And there is no, when we say in our written statement, these have not been controverted or disproved by them in their evidences. So now what would happen? According to our case, Utru was survived by 4 sons. Now, each of the 4 sons, therefore I refer to that Hindu provision of Hindu law, where it says that it is the succession is never kept in abeyance. It can never be kept in abeyance. So, moment Utru Gop died, immediately his property devolved on his 4 sons. So each of them had 1/4 each.
4 sons jointly.
Yes, absolutely.
4
Absolutely.
sons jointly.
Absolutely. So what would be the nature of the property 1/4 share which is held by them, although of a joint family? What would happen? So
Undivided 1/4 share.
yes, absolutely. So whether that undivided 1/4 would devolve upon their full blood brother, whether that provision would apply, or it would also go to half blood brother in terms of being treated as a co-parcelary. Let us now
What is the meaning of property devolving through survivorship?
Yes, I'll come. Your Lordship may see what would be whenever there are certain, if Your Lordship would kindly take. Yes. Because there is a Supreme Court judgment.
Edition, 22nd edition.
I'll come to the provision.
You have referred to 21st edition. Hindu Succession Act.
20th edition I have, but more or less identical.
इतना भी डेवलपमेंट नहीं हो जाता है
हाँ,
law में.
थोड़ा बहुत 1-2 पेज का आगे पीछे. First, Your Lordship, if Your Lordship would take up clause 28, which Your Lordship would find at the top of the pages, and at the bottom it is there in the page number. So, first 28, if Your Lordship
At
would.
running page.
No, it is, the clauses are
Or
here.
the clause 20.
Clause 28 is mentioned at the top, and the page number is mentioned at the bottom. So, page number in my book is 102, but clause number is 28, which I am referring. Clause, rule, whatever we say.
Yes. What a Herculean task to compile on this.
Yes, absolutely. And this has repeatedly been quoted by these, all these provisions from Mullah and Hindu law have been quoted by.
आपके पास 21st edition है?
20th है.
हमारी 20
20th.
आपके
ये वाला.
कौन सा?
हाँ, 20th.
नहीं फिर आपको रेफर करने में दिक्कत होगी. 20 हर एडिशन होगा लाइब्रेरी में नहीं. Yes, inheritance never kept in abeyance.
Yes, never kept in abeyance. On the death of a Hindu, the person who is then his nearest heir becomes entitled at once to the property left by him. The right of succession vests in him immediately on the death of the owner of the property. It cannot under any circumstance remain in abeyance in expectation of a birth of a preferable heir, whether such heir was or not conceived at it. So here, for 2 reasons I am placing. First, upon Utru Gop's death, immediately it goes upon his 4 sons, who each have 1/4 undivided share, as Your Lordship pointed out. Now, upon the death of the 2 sons, it would again, issueless, it would again go immediately to the nearest heir. Who would that be? I'll come to that.
Nearest heir of the
Of the
deceased.
person who is dying. Of the person who is dying.
Next paragraph.
Yes.
When the estate of a Hindu.
When the estate of a Hindu has vested in a person who is in his nearest heir at the time of his death, he cannot be divested of the property except by the birth of a preferable heir, such as son or a daughter who has conceived at the time of his death, or by adoption in certain cases of a son of a deceased. Now, I'll come to that also. Now, your Lordship may see what would be coparcenary. Now,
Suppose there is a death in the family. His property he dies issueless. His wife is expecting a child. Then upon his death, the entire property would devolve upon his brother, because he does not have any heir at the time of his death. Correct?
no, in Hindu law, if we go by the coparcenary concept, then if the property is ancestral property in his own hand, then even if he is conceived by that time, then he would have a right. If he is conceived,
Unborn child will have right.
yes, because that is the concept. Now I'll come clarify
Because
that.
this
also.
where the estate of Hindu has vested in a person who is his nearest heir at the time of his death, he cannot be divested of the property except either by birth of a preferable heir, such as son or a daughter who was conceived at the time of his death, or by adoption in certain cases of his son or his.
Preferable means not his own son. That means a nearer person. Now, why all these concepts would come? Now, how coparcenary is formed, it is there in Rule 212 or Rule Clause, whatever we say. 212. If your Lordship, before placing this, if your Lordship holds that all the four sons of Gudru were coparceners to each other, then after the death, the coparceners would be by way of survivorship. But here I'll show that they are not coparceners to each other, because the property belongs to Gudru and immediately they are getting, and coparcenary will be formed only when they have a son, then they would be coparcener to each other with regard
Second
to
generation.
because the property in the hand of a second generation inheriting self-acquired property from his father would now become ancestral property vis-a-vis his own son. Then he would
But
be
it will not be a coparcenary.
coparcenary as regards other son, other. So all four brothers would not be coparcener to each other. Only coparcener now would be formed after the second generation has a subsequent son. Then these three now they would be coparcener. So here
Exactly. The property of Gudru was self-acquired by him. Upon his death, it became the ancestral property of all his sons, but still it did not constitute a coparcenary property, as his sons did not constitute a coparcenary.
they were not coparceners to
Who are
each
this
other.
property?
Yes. And your Lordship may kindly turn to page 361 approximately. Clause rule is 212. How coparcenary is formed and what is the genesis of a coparcenary?
He has submitted that the first generation does not form a coparcenary. It is the second generation who may form.
Second with third generation.
Second with third generation would form the coparcenary with respect to the property of the first generation.
Yes. Inherited by the second generation.
Inherited by the second generation as ancestral property.
Now your
Okay,
lordship,
clause number?
212.
Everything.
Formation of co-parsimony. The conception of a Hindu family.
You read 211 also.
Yes.
You can exclude the illustration, but you read 200.
Yes, I can read. Now, first we must also see then joint Hindu family, because that would clarify what is then.
Let's see.
Joint Hindu family consists of all persons lineally descended from a common ancestor and includes their wives and unmarried daughters. A daughter ceases to be a member of her father's family on marriage and becomes a member of her husband's family, and reference to so and so. Then here I'll pause. Here the distinction in let us, your lordship may go back to prior to 1956 or original concept of co-personality. Now the daughters are also included, but initially the joint Hindu family included the person whose property was there and his wife and daughters and son. All of them jointly constituted a joint Hindu family. Co-personality, now what is co-personality? It is a narrower body which is now defined in 211. A Hindu co-personality is a much narrower body than the joint family. It includes only those persons who acquire by birth an interest in the joint or co-personality property. These are sons, grandsons and great-grandsons of the holder of the joint property for the time being. In other words, the three generations next to the holder in unbroken male descent. Here I'll pause, your lordship. Here your lordship may kindly see that two things are mentioned. Who is a co-parsoner who acquires by birth an interest in joint or co-personality property. So now here if we apply this principle in our case, then by birth, the four sons, they did not acquire an interest by their birth, because it was self-acquired property of Guru. Therefore, but merely by birth, they did not become a co-parsoner. So what they acquired, therefore they did not acquire by birth. So they did not become co-parsoner. And these are sons, grandsons and great-grandsons of the holder of the joint property. So Udru was not the holder of the joint property, and therefore his sons would not have become co-parsoner. Now, the above proposition must be read in the light of what has been stated in the note of so and so. Then your lordship may skip. To understand the formation of a co-parsonery, it is important to note the distinction between ancestral property and separate property. Property inherited by a Hindu from his father, father's father, or father's father's father is an ancestral property. Property inherited by him from other relations is his separate property. The essential feature of ancestral property is that if the person inheriting it has sons, grandsons or great-grandsons, they become joint owner co-parsoner with him. They become entitled to it due to their birth. These propositions must also be read in the light of what has been stated in the note of the above top of the chapter. So here, your lordship, I may be allowed to explain this. Now here it says that the property inherited by a Hindu from his father. Now the sons of Gudrugo are in the second line. They are inheriting the property from their father. So it becomes ancestral property in their own hands, but it would only be to their own sons and grandsons, not to their brother. Therefore it says property inherited by him from other relation is a separate property. The essential feature of an ancestral property that if the person inheriting it has sons, grandsons or great-grandsons, they become joint owners, co-parsoner with him. They become entitled to it due to their birth, these propositions must also change. Now, illustration you Lordship may see, prior to coming into force of Hindu Succession Act, if A had a son B, inherited property from his father.
Just a moment. The essential feature of ancestral property is that if a person inheriting it has sons, grandsons or great grandsons,
Yes.
they became joint owner of the
Yes.
co-pastor.
They are-
But it does not include brothers.
Brothers, yes. Their own lineal descendant have become co-partner along with these sons of good rulers, not the brothers of
So according to you, the brothers would be tenant in common?
brothers who
Would be tenant in common? Joint owners?
joint owners.
Same thing.
That definition I always get confused in what is tenancy in common and what would be tenant.
Joint owners. Joint
Yes.
owners.
Yes.
Joint owners concept is in the Hindu laws.
Now read further.
Yes.
Ancestral property.
Illustration, Your Lordship may kindly.
Which one?
Illustration first, A.
Yes.
Prior to coming to force of Hindu Succession Act, if A, who had a son B, inherited property from his father, it became ancestral property in his hand, and B became a co-partner with his father. Though A, as a head of the family, was entitled to vote and member.
There is no bar in the law. There cannot be a co-partner. Father
Ah.
cannot.
एक
हम तो
उनको बोलने दीजिए.
आपको पूरा
आप इसका ना आप इसके तह तक पहुंचो. इनका कहना ये है कि upon death of a father who is having self-acquired property, his sons they do not constitute co-partner. His argument is that had one of the sons had more sons, his sons, that is grandchildren of the father, then under such circumstances, he along with his grandsons would constitute a co-partner
Yes, I
with
got
respect to that self-acquired property, but the brothers by themselves, they do not constitute a co-partner, and therefore the property upon death of two brothers will not devolve by separation.
That what
Yes, exactly.
I will ask
This
him.
is, this is my submission.
Let him ask.
ठीक है?
And to
और ये लीजिए.
prove that Your Lordship.
इसको लिख के दीजिए. You do this. Write it down. Saurabh.
We actually do it by watching
I
it
just-
YouTube also we follow it.
You follow YouTube. Anyways, I'll just dictate it once again. The core argument of the appellant is that the property involved in this case was the self-acquired property of Kutubo, and upon his death, it devolved upon all the four brothers, but the four brothers got the property as ancestral property, but not as co-pastory property, as the four brothers do not constitute a co-pastory qua the self-acquired property of Muhammad. He has also submitted that had the brothers further issues, then the portion of the property which would devolve upon one or the other brother, that will constitute a co-pastory property with his sons.
His sons, yes. Sons, grandsons, whatever.
He has also submitted that joint Hindu family is wider. The Hindu co-pastory is narrower than joint Hindu family, and ancestral property is just a species of co-pastory property. यही तो है.
और एकदम और क्लियर हो गया नेक्स्ट पेज में. Your Lordship may see the next page. Ancestral property is a species of co-partnership.
That's what I read and
Yes.
dictated.
Yes. As stated above, if a Hindu inherits the property from his father, it becomes ancestral in his hands as regards his son. In such a case, it is said that the son becomes a co-partner with the father as regards the property so inherited, and the co-partnership consists of father and the son. So nowhere brothers come in this picture. Now, this was
He has referred to clause 210, 211 and 212 of
Again, next page, Your Lordship, genesis of co-parcenary, same thing. It would be, make it clearer that therefore I'm only a genesis of co-parcenary. A co-parcenary is created in the following manner. A Hindu male A who has inherited no property at all from his father, grandfather or great-grandfather acquires property by his own exertions. Here, Gudru Gop is acquiring property. He has not acquired anything from his father or great-grandfather. So, he is acquiring property by his own exertions. A has a son B. B does not take any vested interest in the self-acquired property of A during A's lifetime. But on A's death, he inherits the self-acquired property of A. If B has a son, C, C takes a vested interest in the property by reason of his birth, and the property inherited by B from his father, A, becomes ancestral property in his hands, and B and C are proportional as regard the property. If B continues to join, so and so. So here, same thing, if Your Lordship applies to the fact, then as Your Lordship has already dictated, his own sons would have become co-partners if the persons who had died, they had a son.
you read 212 also.
One,
2. Article 212. Formation of
yes. The conception of joint Hindu family consisting of a co-partnership is that a common male ancestor with his lineal descendants in the male line within 4 degrees counting from and inclusive of such ancestor, or 3 degrees exclusive of the ancestor. No co-partnership can commence without a common male ancestor, though after his death it may consist of collaterals such as brother, uncles, nephew, cousins, etc. So here probably Your Lordship, I'll come. In the morning itself I had read and it was clear.
देखिए इसका illustration देखिए.
Table
Table देखिए.
shows a co-partnership consisting of several families. A with his 3 sons, B, C and D, and grandsons constitute the main family. B with his 2 sons, E and F.
ये टेबल में देखिए. A का 3 बच्चे हैं, B, C, D. B has 2 sons, E and F.
B has 2 sons.
C has 1 son. D has 2 sons, H and I. I has 2 sons. Correct? On A's death,
Yes.
the co-pastory will consist of all of the 3 brothers, B, C and D.
ठीक है.
ठीक है?
But
And their main issue.
And their main issue.
हाँ.
On death of B and C, the co-pastory will consist of D, his nephews E, F and G, and his male issues H, I, J.
Yes.
So brothers by
Many.
themselves constitute co-pastory, but according to you, this co-pastory would be qua the ancestral property
Yes, only
in the
one.
hand of A,
Yes.
and
It is-
not the self-acquired
Yes,
property in the
therefore-
hand of A.
The entire difference is that if it is ancestral properties in the hands of A, then the matter would be absolutely different. But if it is self-acquired property, then the basic concept of co-personary is that if it is acquired by A, it devolves on his own sons and it becomes a co-personary ancestral property in their own hand, who are their own sons or further descendant.
अब देखिए genesis of co-personary.
हाँ, because I'll clarify. I have a Supreme Court judgment.
Must.
Therefore,
These are very common issues which
yes.
are coming up.
Therefore,
They must-
I just wanted to point out because these are the provisions that have been quoted in that.
yes.
Therefore,
Can
I
we
was-
read this genesis of co-personary?
Yes, a co-personary is created in the following manner. This is absolutely clear. Now, Your Lordship may see. A Hindu male A who has inherited no property from his father, grandfather, or great grandfather acquires property by his own exertions. Exactly same situation is there.
Yes.
Gudru had no property which he
Fair enough.
acquired. Then it says A has a son B. B does not take any vested interest in the self-acquired property of A during A's lifetime.
Yes.
So here also same thing.
Yes.
But on A's death, then he inherits the self-acquired property of A. If then now the co-personary is being formed.
Yes.
After
If B
if
has
B has a son C, C takes a vested interest in the property by reason of his birth, and the property inherited by B from his father A becomes ancestral property in his, that means in B's hands, and B and C are co-partners as regard the property. If B and C continue to join and C and a son D is born to C, he enters the co-partnership by that by mere fact of his birth. Moreover, if C is subsequently born to D, then he too becomes a. So
your entire case is that none of the brothers acquired any right over the property by virtue of birth.
but yes,
And therefore
exactly.
Therefore, upon death of Gudru Gop, they did not form a co-partnership
Co-partnership, yes.
with respect to this property.
Yeah, with respect to this
Because
property,
they never formed a co-partnership with respect to the
each
property
other.
of Gudru
Yes,
Gop.
yes.
Even with Gudru Gop, they did not form a
they
co-partnership
could
qua
not
this
have.
property.
Absolutely, disagree. Now, Your Lordship may kindly see the judgment on which I am relying. Slight different fact, but Your Lordship, if Your Lordship says that I'll disclose all the fact also, it would be better that
Little
Your
fact should be there.
Lordship may kindly see the fact itself.
Yes.
I may be allowed to use this very
Yes,
short
please.
time.
Read it.
Srimati Deepo, plaintiff in suit number 8 of 1962 in the Court of Subordinate Judge First Class, Amritsar, is the appellant in the appeal by special leave. She sued to recover possession of the property which belonged to her brother Bua Singh, who died in 1952. She claimed to be the nearest heir of Bua Singh. The suit was filed in former so-and-so. The suit was contested by defendants who are the sons of Ganda Singh, paternal uncle of Bua Singh. The grounds of contest were that Deepo was not the sister of Bua Singh, and that even if she was a sister, the defendants were preferential heirs according to the custom, as the whole of the land was ancestral in the hands of Bua Singh. The learned subordinate judge held that the plaintiff Srimati Deepo was the sister of Bua Singh. He found that most of the suit properties were ancestral properties in the hand of Bua Singh, while few others were not ancestral, proceeding on the basis that according to the custom, the sister was excluded by collaterals in the case of ancestral property, while she was entitled to succeed to non-ancestral property. The learned subordinate judge granted a decree in favor of the plaintiff for so-and-so share of the so-and-so scheduled lands and 13 by so-and-so share of land is described in plaint B schedule. The plaintiff preferred an appeal to the district judge, Amritsar. It was dismissed Second appeal also, Your Lordship, dismissed.
That's
On technical ground it was dismissed, but then the Honorable Court said, Your Lordship, after 5 to 6 lines, Your Lordship may see 10 lines approximately.
yes.
Instead of sending the case back to the district judge for disposal on merit, we have ourselves heard the appeal on merits. The finding that Srimati Deepo is the sister of Bua Singh is a concurrent finding, and we accept it. We also proceed on the basis that according to the prevailing custom of the area, collaterals and not the sister are preferential heir to the ancestral property in the hands of the propositors, while the sister and not the collateral is a preferential heir in regard to non-ancestral property. We must add here that we are not quite satisfied that the custom has been properly established, but for the purposes of present case, we proceed on the basis that the custom has been established. But this is not the end of the problem before us. No doubt the properties which have been found by the lower court to be ancestral properties in the hand of Bua Singh are the properties which originally belonged to Bua Singh's ancestors. Here the main finding starts. Bua Singh's ancestors. But Bua Singh was the last male holder of the property and he had no male issue. There was no surviving member of the joint family, be it descendant or otherwise, who could take the property by survivorship. The property inherited from paternal ancestor is of course ancestral property as regards the male issue of the propositors, but it is his absolute property and not the ancestral property as regards other relations. So other relations, that means brothers also. In Mullah's Principles of Hindu Law, 15th edition, it is stated in page number so and so, if A inherits the property whether movable or immovable from his father or father's father or father's father's father, it is ancestral property as regards his male issue. If A has no son, son or son in existence, at the time when he inherits the property, he holds the property as absolute owner thereof and he can deal with it as he pleases. A person inheriting the property from his 3 immediate paternal ancestors holds it and must hold it in co-parcenary with his sons, and sons. But as regards other relations, he holds it and is entitled to hold it as his absolute. Again in page 291, it is stated, the share which a co-parcener obtains on a partition of ancestral property is ancestral property as regards his male issue. They take an interest in it by birth when they are in existence at the time of partition or are born subsequently. Such share, however, is ancestral property only as regards his male issue. As regards other relations, it is separate property. And if co-parcener dies without leaving male issue, it passes to his heirs by succession, not by survivorship. We are therefore of the view that the lower court were wrong in refusing to grant a decree in favor of the plaintiff as regards the property described by them as ancestral property. The defendants were collaterals of Bua Singh, and as regards them, the property was not ancestral property and held the plaintiff was a preferential heir. The plaintiff was entitled to a decree in respect of all the claimed property, the judgment of decree of so and so. So here, Your Lordship, exactly identical situation would arise, that it could have been, as Your Lordship has already taken note, that it could have been ancestral if the descendants were there. The co-parcenary, they would have formed a co-parcenary, not who are the other relation. That means it was in separate property as regards his own share. So, moment he died, in terms of section 18 of Hindu Succession Act, and even if it is assumed that he had died before 1956, in both the cases under old law, Hindu law also, the same thing existed, which I had already placed on the first.
The learned counsel for the appellant has submitted that upon death of Gudru Gop, the 4 sons did not constitute a co-parcenary or the self-acquired property of Gudru Gop. Although upon his death, the property constituted ancestral property for them. And therefore, upon death of two sons, the property will not devolve by survivorship. Rather, it will devolve upon full brother and not half brother.
By succession, normal
By
succession,
succession.
to preferentially.
By succession, by referable to section 18 of the Hindu Succession Act. Let's hear him on this.
Yes.
बताइए section 18 में क्या बोलना है?
Milord, to appreciate Milord, section 18, I would like to Milord, refer some more sections.
Only last thing, Your Lordships, the finding of the appellate court is that because they are co-partners, therefore it survives.
The learned counsel has submitted that the finding of the learned first appellate court is that because all the four brothers constitute co-pastory, therefore the property would devolve by survivorship and not by succession. He submits that the four brothers did not constitute co-pastory qua the self-acquired property of Kutubo, and therefore the property would devolve by succession and not by survivorship. यही है कोर्ट?
Yes.
Yes. Milord, I would like to place definition, section 3 of the Pregnant, etc. has been defined. May kindly see E. Full blood, half blood, and equal. Two persons are said to be related to each other by full blood when they are descended from a common ancestor of the same birth, and by half blood when they are descended from a common ancestor by different births. Milord, my first submission I would like to make is that so far as the property of Lasuk is concerned, it is a property of Guru. And for that property also, he is also my half blood, I am also his half blood.
Both parties are half blood of each other.
It. Apart from Milord, may kindly see Milord, rules of succession. Milord, before that, Your Lordship, I would like to place section 4. Overriding effect of the Act. Save and otherwise expressly provided in this Act. Only text, rule or interpretation of Hindu law or any custom or any use as part of that law in force immediately before the commencement of this Act shall cease to have effect with respect to any matter for which provision is made in this Act. Any other law in force immediately before the commencement of this Act shall cease to apply to Hindus so far as it is inconsistent with the provisions contained in this Act. Then Your Lordship may kindly see what is the general rules of succession so far as the Hindus are concerned. It is not in dispute that it is the property of a Hindu male. General rules of succession in the case of males. The property of a male Hindu dying in the state shall be
Section
not
8.
according to
Section 8. Section 8.
General rules of succession in case of males. Property of a male Hindu dying in this state shall devolve according to provisions of this chapter. Firstly, upon the heir, being the relative specified in class 1 of the schedule. Secondly, if there is no class 1 heir, then upon the heirs being the relative specified in class 2. Thirdly, if there is no heirs of class 2, then upon the agonists and deceased. And lastly, if there is no agonist, upon the co-heirs. Then order 9, section 9 says, order of succession among the heirs in the schedule. Among the heirs specified in schedule, those in class 1 tax shall take simultaneously and to exclusion of all others. If class 1 here is available, it will not go to class 2 or class 3. Then, my lord, section 10, your lordship will see. And my lord, sons, your lordship comes under, my lord,
Class 1.
class 1, and both are sons. Distribution of property among heirs in class 1 of the schedule. The property of an entity state shall be divided among the class 1 heirs of the schedule in accordance with the following rules. It is state widow if there are more if there are more widows than one, then all the widows together shall take one share. The surviving sons and daughters of the mother and entity state shall take heirs in the branch of each deceased son or the predeceased daughter. The redistribution of share referred in so and so. Among the heirs in predeceased son shall be made shall be so made that his widow or his surviving sons and daughters get equal portion, the branch of his predeceased son, and same portions. Among the heirs in the branch of predeceased daughters shall be made so that the surviving sons and daughters get equal portion. Section 10 Malak describes how the property is to be distributed. 12 Malak, it is orders of succession and agreements and importance. Then your lordship may kindly see rule 15.
12
Section
is not relevant.
So far as we are concerned,
12 is not relevant.
12
12 is not relevant,
Not
even
relevant.
10 is not relevant. Because
10
they are
10
all
is
class.
also not. Yes.
So we can forget.
9 is relevant.
Yes, 9 is.
Then 14 is section 14 also Malak, it general rules of succession in case of females.
This we are not concerned.
Order of succession and manner of distribution among the heirs of female. Then your lordship may kindly come. 18.
18.
Heirs related to an intestate by full blood shall be preferred to heirs related by half, if the nature of the relationship is same in every other respect.
So the
But-
heirs
I'm coming-
related to Gudrugo,
No,
if
let-
they are
let-
full
let-
brother
let-
or half
let-
brother,
let me come. Your lordship may kindly see the plan. Who are the plaintiffs and who are the defendants?
they are the
Plaintiff,
descendants through two different wives.
I am coming to that. Your lordship may kindly see original plaintiff. Your lordship was Rama.
Yes,
Then
Ramago.
Rama. It is 97 2004.
Yes.
Rama Gop alias Rima.
That's
Nato Gop alias Laltha Gop and Vinu, sons of all Bula. Then my lord may kindly see who are the defendants. Mosmat Dunia, then Mosmat Paro, then my lord Hema, Devanandan Gop, Umesh Gop, Damodar Gop, Jannath Gop. That will be more clear, your lordship, from the genealogy.
Genealogy is a part of the play.
Page 17 का plan.
Yes. Yes.
Gududu go. Did my lord find?
Yes, yes.
First wife,
Yes.
second wife.
Yes.
Girdhari go, Budhu go, Mithu go. Two sons were there who died as soon as. And Bola go, son is Vasudeva, he also died. Rima, Latva and Budhu, they are the plaintiff. And my lord, Budhan Gop died as soon as. Samar Gop wife, Mosmat Dunia is the DW1, D1, and Dima Gop wife is D2. Govardhan Gop sons are
Defendants are the descendants of Girdhari.
No, the descendants are the descendants of Bola.
The plaintiffs are the
Defendants are of Gadari.
Gidarigo.
Yes.
Defendants are the descendants of Gidarigo,
Yes.
and plaintiffs are the descendants of Bulago. Remaining two have expired issueless.
Yes. Now, my lord, the point which I want to, my lord, bless you. Heirs related to an intestate by full blood shall be preferred to heirs related by half blood if the nature of relationship is same in every aspect. Here, my lord, widow is also there. My lord, their sons are also there. Relationship only if it is brothers only, then the matter would be otherwise. That I'm giving an example. Suppose, my lord, a person dies. My lord,
Widow of these four children, and Gudru Gop is not the party. Widow of the descendants of Gidari Gop are the party.
like what I'm saying. Your lordship may call you. Suppose a person dies, and my lord, he leaves his property, and my lord, there are full bloods and half bloods, my lord, sharers. Then in such a situation, my lord, the half blood, full blood will be preferred. Here in this case, my lord, it is not, my lord, partition is not being, my lord, sought for, my lord, the brothers who have died issues. It is a property of Gudurugo. So, my lord, this very application of section 18 will not happen.
Because property is not devolving upon any half blood or full blood of Gudru Gop.
Yes,
This is what you want.
this is what I want to say. Had my lord, the property of, my lord, both these brothers, if this was under dispute, then in such a situation, my lord, admittedly, my lord, he could have said that yes, we are the full blood, and my lord, the full blood will be preferred to the half. My lord,
The plaintiff is talking about the share of those two brothers who have died issueless.
No, he says so. He says so.
Yes,
But-
and his contention is that if the property is to be divided amongst two branches of first wife and second wife,
Well,
then under such circumstances, the property which could have been earmarked for two brothers who died issueless, it will go to Vidhan.
my lord, there is a concurrent finding, my lord, of two courts with respect to Schedule B to T, that there is a no partition by needs.
That's right. There has
Then,
been
my
no
lord, when
partition.
such a finding comes here, then, my lord, everything is okay. Your lordship may kindly appreciate. Now it is the court to decide. On the last opinion, my lord has said so. My lord, in this particular case, only property of these two, but the brothers, my lord, of the sons of the Gidhari group, your lordship, is not being partitioned. And, my lord, his claim for preference is with respect to that. My lord, our High Court, your lordship. Our High Court, my lord, in the year 2006, it is a party. This judgment, your lordship, all these issues were considered. And, my lord,
उनको भी दीजिए ना.
Hadith, ये वाला केस में ऑर्डर 23 रूल 5 का में पार्टी बनाने के बारे में था, लेकिन सेक्शन 18 वाज अंडर कंसिडरेशन. तो नेफ्यू एंड कजिन का केस था, उसमें उन्होंने कहा कि नहीं, पार्टी शुड बी सेम और आपका सिमिलर फुटिंग पे होना चाहिए था, तभी से सेक्शन 18 का हम ये देखें. तो इस केस में सेक्शन 18 का एप्लीकेशन को कोर्ट ने कहा कि नहीं applicable. हमारा कहना है इस पर्टिकुलर केस में सिर्फ दो ब्रदर्स का ही तो नहीं है, ये अदर उनके sons भी हैं और उनके widows भी हैं. So many other persons are also parties to the partition suit. इसमें बहुत से प्रोविजंस को कोर्ट ने देखा.
कौन सा फाइंडिंग आप बताइए, कौन सा आप
अधिकार.
करना चाहते हैं?
कोर्ट ने बहुत सा प्रोविजन डिस्कस किया है. 3 सेक्शन 3 डिस्कस किया है, 4 डिस्कस किया है, 9, 10 सब डिस्कस किया है. डिस्कस करने के बाद इन्होंने ये भी डिस्कस किया है क्लास 1 क्लास 2 ये सारा चीज़ को डिस्कस किया है. और उसके बाद इन्होंने कहा प्रिवी काउंसिल का जजमेंट भी दिया कि पुष्कर नारायण शाही appearing for the petition of the against for by the HAP relied upon 1950 PC Ganga Sabha versus Kesari which reads that this argument in the lordship opinion would apply equally force to the case of the half brothers and the case of the brothers of the whole, but it considered that the author of the Akshara has expressly declared that the brothers of the half blood comes before the nephew of the whole, and in principle they seem reason to differentiate between the brothers of the propitiator and the brothers of his father. With regard to the general scheme of Mitakshara, the lordship think that the preference of whole blood to half blood is confined to the members of the same class or to the language of judges of the High Court. In Subha Singh versus Sarfaraj converts to Sapindas of same degree of descent from the common ancestor. He then also referred the provisions of section 15D of the Act and to the section 8 of the schedule. He then referred to section 5 in given in Mula law 19th edition with reference to section 18. His submission was that it applies only to conflicting claims of the two heirs of the same seniority relationship with the deceased. One of the whom is a half blood and other gets excluded in preference of before relation. It has no application in a case where the relationship is at a different levels. On the other hand, the learned senior counsel appearing for the contesting opposite parties submit that first section 18 has to be applied and all the heirs of whatever degree falling in half blood to have excluded and then from among the full blood heirs an appropriate heir has to be selected with reference to the schedule. Learned senior counsel appearing for the opposite party has placed reliance on the full bench of the Bombay High Court in case of Vaman Govind Singhure and others, AIR 1984, in regard to the interpretation and applicability of section 18. Both parties do not dispute that the original plaintiff Banasi Devi died yesterday and without husband. The matter of succession would be dealt in terms of section 14(1)(d) of the Act, where the party would devolve on the heirs of the father as if on the date of death the party belonged to the father who died simultaneously. So far as the decision of the Privy Council Sutra, cited by some Pushkar Naran Sai is concerned, it is requirely come to his aid and in fact, on the fact the case is most appropriate for this court. But as the Privy Council itself noted that there is a rule of the Akshara law, and therefore in terms of section 4 of this Act, it has no application if it is found that the provision and interpretation of Act leads to a different conclusion. It is well settled that once the law with regard to succession among Hindus has been codified, making drastic change in otherwise well-established norms of succession, the codified law will have to be given effect as against the pre-existing practice of rules. As noted above, the preliminary question is what is the scope and ambit of section 18 of the Act, as it asserted by Sri Sahi to come in operation. Only if the contesting parties are related to same degree to the deceased and has no application in other circumstances, or it is the first to be applied to exclude half blood relations in all contingencies in preference to the full blood relations irrespective of degree. I contention before election that the property is of the group. And my lord, so far as both the parties that are concerned. They are half blood to each.
You see, the core issue is whether the property of Gujruko will devolve upon them by survivorship.
Yes, I agree.
That is the core issue.
Now the question, Your Lordship,
And this will depend
I-
upon as to whether the four brothers they form a co-pastor.
But my Lord, make clear, it is not in dispute that it is the Guduru property was acquired by Guduru. It is not in
Self-acquired.
dispute. And my Lord, as per their own my Lord written statement, he said that during the
Written
lifetime.
statement से नहीं decide
नहीं, हम
करेंगे ना,
written
ये तो
statement-
law decide करना हम
हमको
लोग.
law ही
Relationship
decide-
is very clear. Relationship is very clear.
Relationship, what he is saying, that after death he inherited.
After death of Gujruko, all
But
four
in-
persons
But in the
inherited.
written statement, it has come that during the lifetime he has given. How it is possible? You can inherit only when the person dies.
You see, during the lifetime he has given, that is not the finding. Written statement में कुछ भी हो, that is not the finding. But during the lifetime he had distributed the property, तब तो inheritance की कोई बात ही नहीं है, section 8 का कोई काम ही नहीं.
हम भी कर रहे हैं, कहाँ से हुआ है?
नहीं,
ये
भाई,
चीज इनका
उन्होंने
अपना written statement
उन्होंने
के खिलाफ
अपने
नहीं पास
written
कर
statement नहीं खिलाफ की बात नहीं है ना. Ultimately finding क्या हुआ? Previous partition या previous division का कुछ तो prove नहीं हुआ ना, नहीं हुआ. So what we are looking at? We are looking at a deceased who has left behind him self-acquired property. We are looking at as to how the property of a deceased of such a nature will devolve upon his four sons,
No,
or maybe two sons,
one, two sons.
or two sons. Right.
My Lord, we stand your Lordship, that the four sons.
And it has also come on record that out of the four sons, initially there were four sons, and they did not die during the lifetime of Gujruko.
No, but it is their own written statement that during the lifetime the father had given the consequence. That is their case. That is one of these cases. But that
Those
was
are not the point of law. That they
that was
can't should be
disbelief.
given.
That
not
was
be
disbelief.
given.
No,
That
that
was
was disbelief. That was disbelief. And my Lord, learned appellate court as well as the trial court came to a categorical finding that there is no partition by which.
That's right.
Yes.
There's no partition.
So first question, Your Lordship, for deciding.
So it constitutes a joint Hindu family property, self-acquired property of Gujruko, ancestral property, but his cases it is not a co-pastoral property.
Not make any question. So far as the property in question, Your Lordship, is, they are asking for application of section 8. That what is the point of law? Which
That's right. They are asking for an application of section 18 for two deceased sons of Gujruko.
Whether the first appellate court has committed illegality in reversing law, that is regarding the thing. Whether the court below have misconstrued section 18 of the Hindu Succession Act while dealing with the law of succession regarding the inheritance of the property of the Guru. They are not claiming the property of the brothers. This is substantial question of law.
Succession Act में section 18 पर क्यों आए?
Section
Full
18
blood, half blood का point क्यों आए?
ये पॉइंट ये आया
इसीलिए आएगा
क्योंकि अपलेट कोर्ट में ये बहस किया ये नीचे कोर्ट में इन्होंने बहस नहीं
ठीक।
किया अपलेट कोर्ट में इन्होंने बहस किया इनका कहना था कि इस पर्टिकुलर केस में पार्टीशन सूट में सेक्शन 18 विल अप्लाई एंड एज पर द सेक्शन 18 हाफ ऑन हाफ नहीं होगा इनका 3/4 होगा हमारा 1/4 इसी पॉइंट को लेकर के एक तो पॉइंट इन्होंने फ्रेम करवाया बट प्रॉपर्टी
इनका ये कहना है कि all the four brothers they stood on same footing. Squaw Gujruko.
So far as the plaintiff is concerned and even the written statement is concerned, my lord, there is no death of death. There is no death of wife. There is no nothing like that. To ascertain that who died first, if suppose for a even if it is governed by succession.
देखिए जो चीज है नहीं उसको तो हम लोग ला
नहीं ला सकते इसीलिए तो हम भी कह रहे हैं जो चीज नहीं है उसको नहीं ला सकता उसको बहस नहीं किया जाना चाहिए यहाँ पर ये
Is there any finding that Gudru Gop died leaving behind his 4 sons?
ऐसा तो इनका फाइंडिंग हमको नहीं लगता है कि है। इनका फाइंडिंग जो कोर्ट का हम लोग का यही केस था, हाफ एंड हाफ है, और हम अपना रिटर्न अपना प्लेन पढ़ते हैं।
Is there any finding that Gudru Gop died leaving behind him 4 sons? Plain written statement में बाद में, पहले finding बताइए. Is there any finding to that effect? That he left behind him 4
हमारा
sons?
केस क्या है कि हम एक लाइन छोड़ सकते
हम लोग post lunch बैठेंगे. Post lunch will continue.
हैं।
I want to raise वो एक तो judgment आप ही का लिखा है.
So we got all sir आपने भी केस किया।
2:15 बजे के लिए रखे हैं क्या?
वो दूसरा वाला
कौन सा वाला?
संथाल वेदर
देखिए ये है ना, इसको खत्म करेंगे तभी हम लोग इसको करेंगे. ऐसे पार्ट में तो नहीं कर पाएंगे ना. These things are taking
एक
time.
accommodation हमारा हो जाता तो I would have
इस केस में नहीं
नहीं तो आप दूसरे
नहीं, इस केस में आज ही कंक्लूड करेंगे.
दूसरे केस में जैसे
नहीं ऐसा देखिए, इतना मेरा माइंड कंपार्टमेंटलाइज नहीं है कि एक केस से निकल के हम दूसरा केस में घुसें. नहीं देखिए, सुबह से आप ही का केस सुन है ना, इसीलिए प्लीज. एंड यू हैव ऑलरेडी बीन पुट टू नोटिस व्हाट इज द इशू. और अगर क्लियर लॉ नहीं है इसीलिए ना सेकंड अपील है. नहीं वो आप अपना लंच टाइम में पूछ लीजिए. नहीं प्लीज डोंट. नहीं हो सकता है. just never ending. एक फाइल को हम बहुत दिन तक सेकंड हाफ में कंटिन्यू ही कर रहे हैं.
कल का सेकंड
नहीं आप
जस्ट 24
नहीं
आवर
कर
का
सकते ना.
accommodation
नहीं
वो मैटर योर लॉर्डशिप में पोस्ट इट ऑन
वी विल पोस्ट दैट. देखिए, एक फाइल खोलने के बाद इसको हम लोग
एक दिन तो ये भी लिया तो एक दिन तक
नहीं कल आपको कुछ जजमेंट देना हो तो ऐसे ही दे दीजिएगा. हम आपको मना नहीं करेंगे. हम तो आपको पता है, हम तो फुल टेक्स्ट पढ़ते हैं जजमेंट. हमको जितना समझ आएगा, आपको कोई पैराग्राफ रेफर करना है तो आप कर सकते हैं. लेकिन इस अपील को आज ही हमको खत्म करना है. इसको हम लोग कल के लिए नहीं कर सकते.